Good evening everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 69th lecture series. Today we have gathered here to discuss about a very important judgment. One of the leading cases prescribed for the Advocate on Record examination. The serial number is 79 in the revised notification. Now, before going to the topic, it is our regular practice that we recite preamble of the Constitution of India as our daily prayer. So, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. We strongly believe that preamble our goal and preamble our soul. So with this positive note, Swami Vivekananda, yesterday it was September 11th, where Swami Vivekananda ji addressed at Chicago, a famous Chicago speech. So it is always good that we take guidance from our spiritual leaders. According to Swami Vivekananda ji, the purpose of education. What is the purpose of education? The purpose of education is not mere collection of facts, accumulation of facts, but education means which gives you not only the degree in your hand, but also the character building. A man of character, it should build the character. Number two, it must give you mental strength to see even the obstacles as the opportunities. You should not be afraid of the failure, so-called failure. There is no failure at all, but the society, what they determine as failure, face it. See it as the challenge and the opportunities. That is where your mental strength lies. That is second. Third aspect is the true purpose of education is reasoning, analyzing what is good, what is bad. So reasoning is very important. And last but not the least, that education which gives you independency. You have to stand on your own legs. Don't depend on others. That is the purpose of education given by our Swami Vivekananda ji. Worshipping all our spiritual leaders, let us proceed with the topic for today. That is serial number, AOR exam, serial number in leading case. It is 79, dear friends. The name of the case is Dr. KAVITA KAMBOJ. Dr. KAVITA KAMBOJ, KAMBOJ, versus High Court of Punjab and Haryana and others. Versus High Court of Punjab and Haryana others. Citation is 2024, Volume 7, Supreme Court Cases, page number 103. 2024, Volume 7, Supreme Court Cases, page number 103. So today I will be addressing you by way of two lectures on this topic. Firstly, 69th lecture will give you entire overview about the judgment. But 70th lecture, 70, the lecture will be dealing in detail by taking you to the relevant portions in the judgment. So now let me address the overview of this judgment. If you look at it, Dr. KAVITA KAMBOJ versus High Court of Punjab and Haryana. So there is some grievance or party is aggrieved out of the order passed by High Court. So what is this case is all about, dear friends, and why this case has become a leading case and mentioned for the advocate on record examination. In my humble opinion, this case, why it is a leading case? This case is concerning with the appointment of district judges through the promotion quota, and they have discussed about the power of the High Court, to what extent the High Court can exercise its power. District judges are appointed by the governor with the consultation of the High Court. So the expert body is the High Court. So they have discussed about the power of the High Court in appointing the district judges. So this is the importance of this case. Now let us understand the facts of the case. The facts is very important. My senior used to say, we should take care of the facts. Facts will take care of the law. How beautiful it is. So we must have a mastery over the facts. So please note down this. Haryana, this is arising out of Punjab and Haryana. So Haryana Superior Judicial Service Rules.
So one question.
Sir, you can ask the questions at the end, sir, not during the seminar. Haryana Superior Judicial Service Rules 2007. The Haryana High Court on its administrative side, rule number 6, they have passed certain rules. More specifically, rule number 6 in Haryana Superior Judicial Service Rules. What does it say? For the appointment to the post of district judges, there are 3 avenues, 3 ways in which district judges can be appointed. 65%, first way is 65% of the civil judges senior division. By way of promotion, they can be appointed to the post of district judge. The criteria is seniority and merit list coupled with suitability test. This is for 65%. Let me repeat, dear friends. The criteria is merit cum seniority coupled with suitability test. This is for 65% of promotion of the civil judges senior division to the post of the district judge. That is one way. Secondly, 10%. Second way is 10%. Who fall under this 10%? Here also civil judges senior division, but minimum not less than 5 years of their experience. This is, other terms it is called accelerated promotion. So they are also appointed through competitive examination, limited competitive examination. This is 10%. Remaining 25% is appointed directly from the bar, from the advocates. They will be appointed to the post of district judge through their written examination, through their viva also. This is the scheme of the rules. Now what is the issue here? The issue is the Honorable High Court on its administrative side, previously in the year 2013, The High Court rules has said with respect to only to 65%. Now we are talking only about 65%, not about 10%, not about 25%. The problem arises out of 65%. What is the problem? In the year 2013, how did they select? The selection was based on that the candidate should get aggregate of 50% both in written examination and viva voce. Aggregate. But later on, in the year 2021, the Honorable High Court on its administrative side changed that. From 50% aggregate, the Honorable High Court strongly felt that 50% must be there in written examination also, and 50% must be there in viva voce also, not in aggregate individually. So based on that amendment, now they have recommended nearly 13 candidates. Under 65%, they have recommended 13 candidates who cleared 50% in written examination also, 50% viva voce also. Now, appointment recommendation has gone from the High Court on its administrative side to the state government, that is Punjab and Haryana government. But the state government did not appoint these 13 people recommended by the High Court. Why they did not appoint? The objection from the state government was, there are many more seniors, there are many more meritorious candidates than these 13 people, 13 candidates. Why you have not appointed those candidates? Why you have referred only these 13 candidates? So that was the objection by the state government. And in addition to that, your resolution changing 50% in written examination, 50% in viva voce independently was not consulted with the state government. Therefore, the resolution passed by the High Court will not bind on the state government. Therefore, we will not listen. To put it plainly, they said we will not listen. So, this is the difference of opinion between the High Court and the state government. Now, who is aggrieved? 13 people who were about to get appointed, they were aggrieved. So, they filed a writ petition on the judicial side with a prayer of mandamus, directing the state government to appoint these 13 candidates for the post of district judge. But out of 13 were recommended, but total how many candidates were there? 39 candidates participated. So those candidates were not selected because they did not secure 50% viva voce. So they wanted this resolution to go away. They wanted to have the aggregate of 50% both in written examination viva voce. So therefore they challenged that this resolution should go. So that is two batch of writ petitions. One is seeking for appointment as per this resolution. Another batch of writ petition saying that this resolution is not valid. Ultimately, the High Court has said resolution is valid, and they have directed the state government to appoint these 13 candidates. But unsuccessful, who did not get into the post of district judge, they challenged it before the Honorable Supreme Court. Ultimately, in Supreme Court, what did they say? What did they held? They held that High Court's order recommending for 13 people are correct. There is no violation of any of the articles, including Article 14, because one of the objections or one of the submissions made by unsuccessful candidates under 65% category, they said, they made a submission before the Honorable Supreme Court by saying that High Court is going to appoint district judges. Now there are three ways: 65%, 10% and 25%. But High Court did not prescribe 50% for written examination, 50% for viva voce, for remaining 10% or for 25%. Why did they do so only for 65%? This is a violation of Article 14. This was one of the major submissions before the Honorable Supreme Court. But the Honorable Supreme Court has held right to equality and equality before law is that you should all stand on the same pedestal. Though you may be appointed for the post of district judge, but you are having a different avenues, you have different experience. First and foremost is all three are distinct under their own ways. So therefore you cannot claim that equality with respect to 10% and 25%. Number one. Number two, whether this classification or prescription of 50% for viva, is it reasonable classification? Is it rational with the object that is sought to be achieved? For that the Honorable Supreme Court has held, we want the best candidate to be selected for the post of district judge. So previously it was only 50% aggregate, but this time the Punjab and Haryana on its administrative side, High Court has imposed 50% exclusively for viva also. The purpose of interview is to understand how a person is, how a person interacts, what is their communication skill. So everything they can study. Overall independence, individual's personality can be studied through an interview. That is the purpose. So the purpose is to select the best candidate, and this is the way to achieve. Therefore, it is not a violation of Article 14 of the Constitution of India. This is one of the major submissions. Secondly, the submission by the party was, it was our legitimate expectation. So doctrine of legitimate expectation was violated. Then the Honorable Supreme Court has said, you don't have legitimate expectation in this case, because they relied upon one Sivanandan case. I will give you the citation, everything, while dealing in detail. Sivanandan case was cited by the parties by saying, there the Honorable High Court of Kerala, Sivanandan, C.T. Sivanandan versus State of Kerala, there they said cutoff will not be calculated at all. They have prescribed minimum marks and no cutoff. That was the intimation to the candidates. After selection, they prescribed certain cutoff. Candidates were aggrieved now, because at the time of participation we know only that minimum eligibility criteria has to be fulfilled. But after playing the game, you are changing the rule, cutoff being prescribed. So this is against the provisions. So that was the case. There it was, in Sivanandan case, legitimacy, the doctrine is legitimate expectation is fine. But that is not applicable to our present case. Why? The reason is, even the selection of the candidates in the year 2021 itself, the High Court has clearly said 50% in written examination, 50% marks in viva voce. So therefore, when you were participated, you all know what was the rule. You all know what was the rule of the game. Therefore, there was no change in between. So where was the legitimacy to your expectation at first? There is a twin test, dear friends. To fulfill or to invoke doctrine of legitimate expectation is, firstly, you have to say that there must be a legitimacy to your expectation, number one. and that expectation went to the extent for the violation of your fundamental right, Article 14. In this case, the first test itself is failed. There was no legitimacy to the expectation. There was no assurance that we will take you. So no question of expectation. Therefore, Sivanandan case will not be applicable here. They have distinguished. Their cutoff was prescribed after the selection. Here no such changing the rule in between. So you participated by knowing very clearly what is the rule. Therefore, legitimate expectation, the doctrine is not applicable. Thereafter they have held with respect to the appointment, role of the High Court. District judges are appointed by the governor with the consultation of the High Court. So governor is considered to be the executive head of the state. And how they have interpreted is, the Honorable High Court will know which civil judge senior division playing a vital role, how they are disposing the case, and is there any complaint against them. So everything they will come to know. But who is the governor? Governor is the outsider. How will he know about the performance of the judges? Because the Honorable High Court, other courts, district courts and subordinate to district courts, all are subordinate to, answerable to the High Court. So High Court has the power. High Court is the expert body. It can analyze, assess the performance of the individual judges. Therefore, the governor must consult the High Court. Once the High Court is consulted, whether that consultation is binding on the governor, yes, it is binding on the governor. This is what they have held. So role of the High Court, how they effectively play at the time of appointment to the post of district judges. Thereafter they have discussed about whether rules are there. When rules are silent, whether it can be supplemented by resolutions like this. Answer is yes. Generally, the notifications or the resolutions passed by the High Court on its administrative side should not violate the statutory provisions. But when a statute is silent, for example, Rule 6 here of the superior rules, where they have said 65% of civil judges senior division is to be appointed based on merit cum seniority list. But how? On what manner? The resolution will fill the gaps by saying you get 50% in written examination and 50% viva voce. So though it is unclear, it is supplemented through the resolution. It is good. But if such resolution is against the statutory provisions, then it is bad. But there is no statutory provisions. So there is a silence. Therefore, the silence can be filled up by introducing the resolutions. Ultimately, what is to be seen is the best candidate has to be selected. How to select the best candidate? The best candidate can be selected only through their performance. So interview is most important. The object of the interview is discussed. So therefore, dear friends, so that is overall. Ultimately, the Honorable Supreme Court has held that 13 candidates are to be appointed. So they have upheld the order of the Punjab and Haryana High Court. And in addition to that, what they have held is, when there was a difference of opinion between the High Court of Punjab and Haryana and the state government requested the union government to interfere and resolve the difference between the Punjab and Haryana High Court and the state government. So that is a wrong approach. This is against the constitution scheme. If there is a dispute between the state government and the High Court, it should be resolved only between two entities. So your approach, state government's approach towards the union government is unwarranted. This is against the constitution scheme. So that is how they have concluded, dear friends. So thank you so much. This is an overview of the judgment. Thank you.